everyone to today's Lunch and Learn, Formation and Licensing, What Founders Need to Know. I'm Adrienne Klein. I'm the Director of Programs and Community Engagement at the Oregon Bioscience Incubator, and I'm really glad that you could join us today. Before we jump in, just a few housekeeping notes. First, that we ask that you stay muted with your microphones during the whole session. And we would love to know who's here. So take a moment to introduce yourself in the chat. Let us know your name, what company you're with, and what you're hoping to get out of this session today. And feel free to connect with others. And I will share my LinkedIn in the chat so we can stay in touch. And Kirsten Santana, our programs coordinator, also here with us, will share hers as well. So we can get some introductions going in the chat. If you have any questions at any point, please go ahead and drop them into the chat, and we will be keeping an eye on those throughout the program and answering them at the end during the Q&A portion. Firstly, Otrati would like to acknowledge the land that we are all on, wherever we may be. Otrati conducts business throughout Portland and beyond and is making an effort to acknowledge the history of the area and work towards decolonization of the bioscience industry. To learn more about Portland's native, diverse, and vibrant community, please read Leading with Tradition, a document created by the Portland Indian Leaders Roundtable, and we'll put a link in the chat for you. I wanted to promote some of our upcoming events. We have our Think and Drink Trivia Night coming up on Thursday, May 7th. Tons of fun, lots of prizes, highly recommend. And then we have our next virtual Lunch and Learn coming up on Tuesday, May 19th. So check out our events page for more information on those two events. At the end of the program, a survey will just automatically pop up on your screen. I would love it if you could take just a couple of minutes to fill out our survey. That really helps us know what programs to bring to you. And I would like to introduce our presenters today. So today we are joined by Tolly and Sebastian from Mints, who bring a really strong combination of legal expertise and real-world startup experience in the life sciences space. Tolly is based in San Diego and has over 25 years of experience advising biotech, medical device, and pharma companies on licensing, collaborations, and strategic partnerships. She also spent time in-house at Invitrogen, so she really understands how to give practical, business-minded guidance to founders and growing companies. Sebastian works closely with startups on financing, corporate formation and governance, and mergers and acquisitions. He's deeply connected to the San Diego startup community and also teaches at the University of San Diego School of Law, helping to train the next generation of attorneys supporting entrepreneurs. Together, they help companies grow and make smart decisions at key moments, and we're really happy to have them here today. So please welcome Tolly and Sebastian.
Everyone, thank you for having us.
Thank you so much. I'll go ahead and share our presentation. Let's see if I can get this done right. And Sebastian, you and I will tag team through this. So our presentation is Launching a Life Sciences Venture. We're going to be talking about corporate formation and in-licensing essentials. And maybe, let's see, Sebastian, if you could, let me see if I can advance. Lead us into why this matters.
Oh, sure. Yeah, I mean, so a lot of, especially putting together an entity, one of the common questions I get, right, is when should I be forming a legal entity? And, it's important to get it formed early enough that you can take the position that the company is worth nothing, and that lets you get your shares of stock with minimal tax consequences. And then kind of the other piece is, once you have someone else developing IP, that's where the need for an entity becomes important. You want to put together the entity and lay the groundwork because this is the starting point, right? Any future transaction you do will circle back and say, okay, was the formation done correctly? Did the IP get put into the entity correctly? If that setup is not done properly, then you're going to have either a financing that you doesn't go through, or which entails a substantial amount of expensive cleanup. And as I mentioned, some of the stuff that becomes a problem is tax related, and the IRS, unfortunately, is not very friendly to, oops, sorry, can we just not pay that? So getting it right is very important.
So, the agenda today, we're going to go through corporate formation basics, including equity, cap tables, and boards, and financing readiness. And those are areas of Sebastian's expertise. And then we'll get into university IP licensing. And the reason why we chose that as one of the kind of essentials for forming a company in life sciences industry is because so often it's the case that companies' essential foundational business is based on intellectual property rights that have been brought in from a university or a research or academic institution. So that's not always the case, but because it's so often the case, whether the founders are themselves associated with the university or research institution, or whether they've identified technology at a research institution, so often that is the foundational element of their business. So we thought it would be critical to cover during this talk.
All right, terrific. So I'll go ahead and jump in here. So I'm just trying to orient, and I apologize because this is definitely a topic where the amount of experience in the audience will vary pretty dramatically from person to person. So I'm going to give you kind of the most basic element. Now that said, if this is not intuitive information by any stretch of the imagination, but you guys are all, I think STEM graduates, so hopefully it all makes sense. If you do have questions, feel free to put them in the chat, and we'll get back to those. So I've listed here, kind of the form of entities. There's really kind of two main considerations when you're forming, which is a limited liability company, which is an LLC or a C corporation. There's definitely other types of entities out there, but those are kind of the two that are the most important. And then, oh, sorry, Tyler, the next slide goes into this in more detail, right?
Yes.
Okay, good. I always get ahead of my overview slides where I'm like doing the overview and I'll just start going into the material. And then we'll talk about the jurisdiction of incorporation. You probably are familiar with the concept that most of the investable companies are going to be Delaware corporations, and that is a well-trod path. I recommend you stay on that path unless you have a very strong reason to deviate. But let's go into the details. So go ahead and hit next. Thank you. All right, so the LLC. The pros of the LLCs is, the limited liability is a feature of any entity. So one of the functions of a legal entity is it protects passive investors. Now, note though, I use the word passive here. This benefit of the limitation of liability can easily be overstated. Where it provides the most protection is like, let's say your Aunt Mildred, just thinks you're amazing, and so she gives you $10,000 to put into your company and buy stock. And then your company, turns out what you do is you build pogo sticks with dynamite in them, and it's really dangerous and they explode, and people bring a suit. Aunt Mildred's fine. Aunt Mildred didn't do anything, right? She just gave you the money and bet on your business savvy. Now you, on the other hand, you're protected as a passive stockholder, but you're the one who put dynamite on a pogo stick and then passed it out to people. They don't need to penetrate the liability shield created by the entity. You're the one doing the bad acts generating liability. So just be aware of that. The protection that the entities offer from liability is mostly to the benefit of your passive stockholders in the background. Um, the LLC is very flexible, and this is both it's in the pros, but honestly, it's a con as much as a pro. So the great thing about LLC is, hey, if we want to say this particular person has a 2% interest, but only relating to this product, we can do that. It'll be messy, it'll be complicated, it'll confuse future investors, but we can do that. And so that's why I say, like, it's good in that you've got the flexibility, but it's a con in that, that flexibility, if used a lot, will get unwelcome attention from investors in the future. Um, the next key piece of the LLC, and this is kind of one of the big differences between an LLC and S corp, is the tax treatment. Now, quickly, I always have to give this disclaimer when I go into a conversation about taxes. I'm not a tax attorney, but I deal with this stuff all the time, so I've got a pretty good sense of how it works. Um, so with an LLC, it doesn't actually pay taxes separately. Instead, what it says to the IRS is, hey, I'm an LLC. I got some revenue or some income generated, and then I allocated it all to my owners. Go tax those guys. And then the IRS comes after you, the owners, and says, okay, hey, we see that you received income from this LLC, and we're here to tax you on it because we're the IRS. That's what we do. It's relatively easy to convert into a corporation. So if you want to start an LLC, you can. Again, I don't love this idea, and I'll get to kind of some of the issues with it. But if you have your heart set on an LLC, or you've already done an LLC, going into a corporation is not that hard. All right, the cons. There's additional accounting involved with an LLC because you're dealing with capital accounts and allocations of capital accounts and kind of complex accounting concepts like that. And then you're also going to give a K-1 to your owners every single year. Because again, the LLC doesn't pay taxes, so you have to give the underlying owners enough information so that they can pay the taxes, and that information is the K-1. It's really hard in an LLC to give equity interest to employees and service providers. The challenge with that is that if you give them some, they're no longer, W-2 employees. That's probably what you're most familiar with. That's the kind of generic employment regime that most people operate under. Well, if you are in an LLC and you have an equity interest, you're not an employee anymore. You're a partner. And so you would then get subject to partnership tax rules. And those are kind of much more complicated, much more painful. So again, it's kind of problematic to grant equity in LLC where this is not an issue in the C Corp. Institutional investors are going to typically object to the LLC, so that's a big deal. They're going a lot of times, if you start as an LLC and you have outside investors, one of the requirements will be, hey, turn this into a corporation. We don't want to invest in LLC. And the reason they're objecting a lot of times is that the investors themselves have investors in them. So the way it works, right, is somebody goes to a bunch of wealthy individuals and institutions, collects the capital, and then deploys it into various startup opportunities. So if they are investing in an LLC, then what happens is the gains of the LLC go into the investor, which then goes back to the investor's investors. Those people may have a big issue with having U.S. income if they're offshore or they are a nonprofit, something like that. So it's not just, they don't like LLCs. There are practical results of an LLC that make it less favorable for them as compared to a C Corp. This next one's a huge one too. The 1202. So 1202 stock, you might also hear it called QSBS, which stands for Qualified Small Business Stock. This only applies for shares in a corporation. And what happens is if you meet a 5-year holding period, and there are some other tests along with that, but kind of the key one at this point is the 5-year holding period, then you have a substantially less significant tax liability because basically the first portion of the gain on those shares doesn't get taxed. And the amount of that is the greater rather of 10 million or your basis in the shares. But again, that's a huge, huge tax benefit. If you have a company and it does well and you meet this holding period, it's going to massively reduce your tax payments and then also reduce the tax payments owed by your investors. So they will also look favorably on this. The last one is net NOLs, net operating losses. In a corporation, I mentioned corporations are taxed as separate entities, and one of the benefits of that is that any losses can be carried forward and applied to subsequent profits. And sometimes investors or acquirers are interested in obtaining those NOLs as well, assuming they can kind of jump through the tax hurdles required to do that. In an LLC, that doesn't happen because any losses are going to be allocated to the members. Now, you individually might be able to deduct that loss from your taxable income, but it's not the same as deducting it at the entity level itself. So that's LLCs briefly. Let's go to the next slide. So the C Corp, look, this is the gold standard. This is where I'm going to push you. It's just FYI. This is where you probably should be unless you have a compelling reason not to be. So we've still got our same limited liability with the same caveats and kind of, distinction between you're actively involved, that shell doesn't provide you much. You're passively involved, that shell is magic and keeps you safe. So those are two different ways of looking at that liability shield. The QSBS stock is a huge one. I already talked about that at the LLCs level. That is a massive tax windfall when we are finally selling these shares, whether an M&A transaction or maybe you're just selling them, secondary. Either way, the QSBS benefits are very significant. I flagged that it's relatively hard to issue equity to advisors and service providers in an LLC. C Corp, it's the opposite. C Corp, what we do is we put in place a fairly simple equity incentive plan. You can use that to issue options. You can use that to issue shares. We don't have the same problem where giving equity to somebody in a C Corp changes their status. So if they're an employee or a consultant, they'll remain an employee or a consultant. They won't become a partner like they would with an LLC when they own the LLC interest. Again, the institutional investors prefer the C Corps. They're concerned, as I mentioned, about having income allocated upriver or upstream to their underlying investors. They really are incentivized to get that 1202 benefit. And of course, corporate law is less flexible than LLCs, but less flexibility means greater certainty. So, if you come to me as a corporate question, I can generally tell you, here's where the answer will lie, and here's where we should look at things and consider things. If you come to me with an LLC question, I kind of will look at you a little bit blankly and say, all right, do you have the operating agreement? Because I need to see what you guys did and how far you've deviated from what's standard practice. There are limits to how much you can deviate from a standard corporation in a way that there are not with an LLC. Cons, look, that strict structure and governance means that it's the other side of the coin. We have greater certainty, we have less flexibility. Good example, if we want to do anything outside of a meeting at the board level, we need all of the board members to sign a consent. If we have an LLC, there's a lot of flexibility in that rule. We could say, oh, well, hey, if we have a majority, they could have approved it at a meeting, therefore they can approve it at written consent. We don't have that flexibility in a C Corp. We either have everybody or we don't have everybody, and we can't get a fix to make that work. So that's just an example, right? But there's oftentimes things where in an LLC, I can say, hey, yeah, we can be flexible. In a C Corp, I'm going to say, oh, gosh, this is going to be hard to navigate around or expensive or problematic. You've got the other issue too that people often focus on is the double taxation. And so the way this works, I mentioned that a corporation is taxed separately. So let's play this out. The corporation has $1 million worth of taxable income, so it then pays the IRS the taxes on that. And then the corporation looks and says, you know what? I don't have a good use for this cash. I'm not going to invest it in the company. I'm going to just distribute it out to the owners. Well, that's called a dividend. The owners receive cash, but then they get taxed separately. So that's where the double tax is, right? First, the corporation gets taxed because it earns the income. Second, the stockholders are taxed if they get distributed out cash. Now, this only is an issue insofar as the company is making distributions of cash. Startups generally aren't doing that. So the double taxation is a much more theoretical risk in my perspective than an actual risk, just because paying out dividends is very, very uncommon in startups. You want that cash used to build the business, and the way you're getting that cash is from the stockholders, not from revenue by selling products and services. So the stockholders don't want to give you money to have you turn around and give them money back. They're going to say, wait, I thought you needed this money to build the business. I don't want it. I gave it to you to do that. Next slide.
Sebastian, I have a quick question for you, and I don't know if it comes up in a later slide, but is in terms of a company hiring a lawyer to do this formation work, is there a significant difference in cost, lawyers' fees, LLC versus C Corp?
Good question. Good question. Yes, there is. And the thing about the LLC is, if you only have one member, which is kind of not a stable position, you're going to have to bring somebody else in. It's extremely easy, extremely cheap. I mentioned that, but it's kind of irrelevant, right? Like if you had a subsidiary, you wanted an LLC, that's very cheap to form. Otherwise, because of the ways in which an LLC can be customized, forming an LLC is more expensive. Anytime there are a range of options and your attorney has to explain those options and then you have to make a choice about which of the options you want, that increases your costs. In a C corporation, the questions that I need are pretty small universe of questions, and what the answers that you could possibly give are relatively narrowly defined. In an LLC, that's much greater. So there's definitely a cost differential, and the LLC is the more expensive of the two. And again, the more you take advantage of that flexibility, the more expensive it becomes.
And part of that is also if your investor insists that you convert, now you have to spend more attorney's fees doing that.
Right. Yes. And then if the investor's having you convert, you've also then lost out on some of that holding period for the QSBS. I mentioned it's a 5-year holding period. It doesn't start running until you actually own stock, shares of stock in a corporation. So if you have LLC interest, let's say you held it for a year, now you have an outside investor, now you're converting to a C Corp, you are just starting your 5-year holding period. You're not 1 year in like you would be if you formed a corp. All right. So the documents that you need as part of a formation, and again, this is corporate focused. So it's the incorporation documents. So the incorporation documents kind of tell us what are the powers of the corporation. Generally, those powers are very broad. It's to engage in business permitted, under Delaware law or California law or Oregon law, wherever you happen to be. And then it tells us kind of the relationship among the various parties. So it'll tell us, hey, we need a majority of the stockholders to do this. This is the process by which you put somebody on the board. This is the process by which you remove somebody from the board. So there's not a lot of negotiations around this. These are just the rules of the road that need to be clear so that we don't have a problem in the future. Our founder agreements, this is your ownership. right? So what the founder agreements are is the issuance of the shares to you. So this is a document that says the company's issuing shares, the founder is putting in cash or maybe IP, the business plan, whatever the case may be, and that's how the shares are issued. And then the concept of vesting. I think we have a slide where we go to that into that in greater detail. But the kind of core concept around vesting is basically if somebody is a founder but then leaves early, you can claw back their ownership. That's the core concept of vesting. One note on the founder agreement. So, one of the common things I try to point out with these types of events is to say, where are the problems where I can't fix them if you've made the mistake before you find me or find a lawyer? This is one of them I can't fix. If you, for example, didn't issue co-founders stock and the company has appreciated in value, I don't have a magical way to go back in time and say, oh, let's just pretend we issued the shares back when the company had a very low value. I can't do that. You have to issue at the value today. So if you drag your feet, you don't give your shares to your co-founders, then what you can find yourself in is a situation where you create tax liability for them or for yourself because you're issuing the shares so late. So do make sure that, because sometimes people think, oh, I did it. I formed the company. I filed something in Delaware. Done. And that's only part of the task. All that does is create the entity itself. It doesn't issue the shares. That's what these founder agreements do. The cap table, I gotta, normally I do this presentation, I talk to lawyers or law students and I warn them this is the math part. I feel like you guys as STEM background people, this won't be as scary. The cap table is the big spreadsheet. It tells us the relative ownership for everybody. And we use that to determine, who has a voting right. Who do we need to assemble to reach a majority of the votes? If we sell the company, who gets paid and how much do they get paid? So that's the kind of information that the cap table tells us. Right now, it's generally a record of facts, right? So we're not negotiating anything here directly. It's just going to say, hey, founder A holds this many shares, advisor A holds this many shares, and so on. Consultant employee documents. So one of the key items you want to have, and this goes, and Tali can, I'm sure, speak much better to this issue than I can, make sure everybody who's touching your IP has an agreement that says the company owns the IP they touched. You could theoretically just make an argument, but one of the things that, the value that is provided by a lawyer and by having an agreement is you're not forced into the vagaries of, multi-factor tests that's going to look at all these elements to figure out, does the company own the IP? If the question ever comes up, you're going to point at a piece of paper and you're going to say, hey, the person who created this IP signed a piece of paper saying the company owns the IP. That's a great thing to have in your pocket, and investors will expect to see that. Equity plan, I've kind of made reference to that. What an equity plan is it's a vehicle where we can give ownership interest to your advisors and your employees. One of the things about working with or for a startup is they generally are not as well capitalized and have as much money as a more mature company. And one of the ways that people then decide that they're going to go forward is because of the equity. That's the benefit that they're looking for. If they're investing in an early stage company, it's less about the cash consideration and more about the possibility that the shares are going to be worth something because they're providing services, to the next Google, and that's what they want to be doing. And then, one of the things you want to think about is kind of your initial board of directors. Rule of thumb would be call it 3 people. It probably might, somewhere around that number. You can have it be less for sure. If it's just you by yourself, no problem having it be a single person director. It's good to have a friend though that you can put in there because one of the things that will happen if you are, the sole person all by yourself, if you bring in investors, usually with the way that will break out is they're going to give you, the founder, 1 or 2 seats, and they're going to have 1 or 2 seats, and then maybe that 5th seat will be somebody that neither of you is friends with, an independent director. So, you kind of want to have that second person that you trust lined up because you want to make sure you've got somebody on the board that can support you and your vision. So if you've got a co-founder, you're already there. If you're doing this solo, just keep an eye out for that person that you might want to have on your board in the future. Again, you don't need them now, but it's something you might want to think about for when, you have another board seat that you want to fill.
Hey, Sebastian, what happens if you form your company and you hire someone to create some IP for your company and they didn't sign a document? And then later your investor comes and says, where's that document? What do you do?
That's a lot of trouble. And you couple options, right? Let me start with the least likely. You convince the investor it's all okay. Well, that'll be dependent on the facts, and maybe it's just a minor trademark. But if it's, the secret sauce that makes things work, it's going to be a huge problem. Next, if you can't convince the investor it's not an issue, then you need to go back to that person and have them sign a piece of paper. If they're sophisticated, they will realize they have leverage, and they're not just going to sign the piece of paper because they're good people. They're going to say, "Hey, why don't you give me some more money or some shares or do something, scratch my back? Yeah, I'll sign your piece of paper." And so you've given them leverage that they otherwise would not have. Now, look, some people, I'm not. Don't mean to say everyone's evil, but my job as a lawyer is to be paranoid on your behalf. And I assume everybody's out to screw you, and I'm trying to protect you. And so, there will be people who will be accommodating and not an issue. But my goal is to make sure that if they're not, you're not in a bad position.
And I think all of this goes to like the first slide, which is, get your ducks in a row early and get them and right. And we know that that costs money, but it's worth it because in the long run, you'll just end up spending more money if you don't get it right.
So yeah, if you make mistakes and you don't do this well or you shortcut it, sure, you'll have an entity, it'll be fine. And then what will happen is the first time an investor comes in, they're gonna have an attorney just like me who's gonna be digging in there. They know all the issues to look for, and they're gonna come back with a list. They're gonna say, hey, you need to fix, these 10, 12 things. And if it's really bad, they'll say, you know what, your company's too much of a mess. We're not gonna do this. So it's very important to have that is point well taken, Tolly.
All right, let's go to 8. All right.
So vesting, this one's a tough one because you're kind of gonna poke at a conversation that's sensitive, and people don't want to poke at this conversation. So I've got a variety of quips I give people about what I do and what to keep in mind. And one of my quips is nobody gets married planning to get a divorce. But prenup's not a bad idea, and that's kind of what vesting is. Vesting is your prenup. Everybody is happy and enthusiastic when you form a company. It's all potential. Nobody has encountered failures or setbacks yet, so everybody is gung ho. As time goes on, maybe the company isn't doing quite as well as everyone thought it would, as fast as it would. Maybe one of your co-founders, it turns out their spouse has to move to Nebraska for a residency, and so they're going to be, not in the office anymore, and you need them present to conduct your experiments, whatever the case may be. But we've got somebody who should be at the table and they no longer are. And so again, if you at the time, like let's say this person was extremely valuable, and even though they're only there for 6 months, they made a huge contribution. Hey, if you guys are friends and you want to deviate, yes, let's do that. We can deviate. I can come up with a solution. But again, what I want to do is put in a place that if you're not friends, you're not going to be in trouble. And so, putting this in place says, hey, we're all in this together. If one of us leaves early, then the company can buy the shares back. Now, keep in mind, when I say buy the shares back, I'm not saying at current value. So if the company is now worth at, trade, let's say you just did a financing at $1 a share, but when we did the formation, we sold shares at a tenth of a penny. We're not going to buy back this person's shares at $1 a share. We're going to buy them back at a tenth of a penny, the original purchase price. And that's the outcome you want, because otherwise what you're doing is giving them liquidity early, and everybody else who's sticking around to continue building value, suddenly, this person has drained money away from the company because we needed to get them out and get their shares out. What we typically see in terms of vesting is what we call 4-year vesting with a 1-year cliff. This isn't mandated by law or anything like that, but it's kind of what investors expect to see. So let's start with the kind of basic concept. At the end of 4 years, you're fully vested. So this ability of the company to buy shares back at the nominal price you paid, that goes away. 4 years, those are your shares. The monthly vesting, that's easy enough, right? We just divide the number of shares you have by 48, and then that amount vests each month. The cliff. Okay, so the cliff is something that probably maybe you're not familiar with. This is a new concept. So what the cliff says is, hey, it's supposed to be monthly vesting, but not for that first year. For that first year, let's make sure that this is a relationship that works, and let's put a little extra time into things before we start vesting shares to make sure that this is a person who provides value and we want them on the team and they're worth the equity we granted to them. And so nothing will vest during that first year. And then you basically get 12 months worth of vesting at the end. And again, that period is for your protection at the company level because it gives you this opportunity to see if someone is a good fit for the team, but you're not going to be out of pocket with all the equity if they're not a good fit and it's a relationship that won't continue forward.
Sebastian, on this topic, I think there might be some folks in the audience who are doing this for the first time and are maybe looking to their attorney for advice on how to allocate equity with their co-founders or with others. Is that the kind of advice that you give?
Not so much. Like how you allocate equity tends to be a business decision because what that should be driven by is, How important is this to the person, to the business? What are they providing? What's the value of what they provide? Um, those are questions that I'm not well equipped to answer with regards to your particular business. I don't know your particular business. And so I can provide some kind of rough rules of thumb. So, for example, I recommend leaving some shares available for consultants and employees just to avoid extra process and filing fees in Delaware. Um, that reserve, I usually say it's 10 to 20%. The other place where I'm going to get a little bit nervous or maybe have some comments is, if we have, let's say, three co-founders and, well, actually, let's go four because it's easier to deadlock. We have four co-founders, they all own 25%. There's a risk of deadlock there, right? And so we might want to think about putting in another agreement to deal with that risk. So anyway, does that answer the question?
Yeah, thanks.
Yeah. All right, 83B. I'm going to say it again. I'm not a tax attorney, and now I'm going to talk to you about taxes. So that's part of being a corporate lawyer is I tell people I'm not a tax lawyer, and then I talk about taxes anyway. 83B. So to understand this thing, you got to understand the IRS and how it views the world. So let me start with a basic proposition, which should be familiar to you. If somebody pays you money for services, the IRS taxes you, right? So if you come over and you write me a study or a white paper and I pay you $10,000 cash, then the IRS is going to come in and say, hey, that's $10,000 worth of income. If instead of giving you $10,000 worth of cash, I give you shares that have a value of $10,000, the outcome's the same. The IRS is going to look and say, we don't care if you got shares or you got other property. That property has a value. We're going to tax you on the value. But the IRS does something weird. When you buy these founder shares, the IRS comes in and says, okay, let me check this out and see what happens. So let's say you put in IP. If you're getting shares for IP, that's the same as getting money for IP. That's taxable. So the IRS comes and looks and goes, okay, we see that you got some shares and you gave some IP. But you don't actually own these shares yet because the company can repurchase them. We're not going to tax you right now because that wouldn't make any sense. We'll come back. So the IRS goes away. The shares vest. Now the IRS comes back and the IRS says, hey, remember when we said you didn't own those shares? Well, you own them now. And now we'd like to tax them for you. And so the IRS will compare what's the value of the shares today, which will be like a year later when they vest, against the price when we first issued them, which is a very, very low price. Probably the value has gone up. I mean, hopefully the value has gone up and you're going to get taxed. And then you know what's going to happen a month later? More shares are going to vest. And you know what's going to happen? The IRS is going to show up again with a tax bill. And they're going to keep doing this until the full 4 years has vested. And they're going to be taxing you on a spread between whatever the fair market value is and the price you paid. This is bad. As I mentioned, like there are some tax problems I can't solve. This is one of your tax problems I cannot solve. At least I can't solve it very cleanly. So what do we do? What you do is you file an 83B. You tell the IRS, hey, IRS, I understand that you don't think I own these shares yet and therefore aren't going to tax me, but God, I love paying taxes and I really would jump at the opportunity to pay more earlier. And so I'm going to file an 83B and I'll just pay taxes now. We don't have to worry about when they vest. And I can't emphasize enough, you can do this. The amount of taxes you're going to pay if you get services, we're talking about a couple $100 worth of stock at a very, because it'll be at a nominal price. The company is good ideas and a piece of paper filed in Delaware. That's it. We can argue that's worth very, very little money. So let's pay the taxes today while the value is very, very low. And then we don't have to worry about this problem in the future. So 83B election, hugely important. This comes up anytime we have shares subject to vesting. That's the magic. And you should have shares subject to vesting. So this should be something that all of you are kind of putting in place and dealing with. And just be aware, this is the IRS. Like I say, out of all of the organs of the government, they're the least friendly, the least willing to look the other way. They're the ones who get the money, and they're serious about getting the money that the government is owed. All right. Okay, and then consultants, employees, just one thing to keep in mind, and this is something where, again, a lot of times you come into this as having always been an employee or consultant, you haven't been kind of on the other side of it. And so you may not appreciate the fact that employment agreements in the US are extremely rare. Generally, only your C-level people, or maybe in more mature senior organizations, they will have employment letters or employment agreements rather. The more common approach, and what I recommend startups do, is just an offer letter. An offer letter just says, hey, there are certain things we're going to need from you to be in compliance with, applicable law, like your proof of your ability to work in the U.S., the tax information we need in order to withhold, things like that. And then, oh, by the way, because you're in the U.S., you can be fired at any time for any reason or for no reason. So it's just laying out the ground rules of being a U.S. employee, and that's kind of all you want to commit to. You don't want to commit to more to that with your employees. And now, look, you might be saying, well, I'm the employee, I'm the founder, I want to protect myself. Yeah, if you put in a very, pro-you employment agreement, one or two things happens. The investors don't put money in because they don't think you are worth all of that employment agreement, or they say, hey, we don't like that, change it, remove it. It'll be a condition to us putting in money that you unwind that. So I wouldn't even do that because you are going to be forced to walk back any kind of very strong employment agreement that favors an employee. Employees and consultants, look, this is an issue that comes up a lot, and this one is very much, it varies state by state. Talia and I are here in California, where it's really, really hard to make an argument that somebody is a consultant. But just be aware because of what the law is, where you have the person providing services. That's what matters here. So even if Oregon has special rules, if you hire a consultant in California, California law is what determines are they a consultant or are they an employee. The big difference from it, from your perspective as the business operator, is that employees you've got to do, tax withholding, and all of the minimum wage laws apply. All of that stuff applies. Consultants, it's a lot more Wild West. You can just kind of say, I paid that guy, and then he told me he'd deal with the taxes. And that's not your problem. That's the consultant's job. So the big risk, right, and again, this is a risk that's very prominent here in California, is that the state comes in and says, yeah, that's not a consultant. That's an employee. So you gave them non-cash, which means you didn't pay them minimum wage, which means you violated California law, and the California authorities are going to come after you. The last piece here, we kind of touched on this a couple different times, a couple different ways, and I can't say this often enough. Have everybody who touches your IP sign a piece of paper saying the IP belongs to the company. This will travel under a couple different names. It's funny because it's a very critical document, but we as a legal industry haven't agreed what to call it. So some firms will call it an inventions agreement. I call it a proprietary information and inventions agreement. It's got a wide variety of names, but the core concept is anyone who touches IP is signing an agreement saying IP belongs to the company. All right. So you touched on some of these already, and I want to make sure, Tali, you have time to talk. So I think that, kind of the big issues here, I've talked about the tax ones are the big ones at the startup that are hard to fix. And the biggest amongst those is the failure to file the 83B or the failure to issue shares of stock at all. Those are the ones that are hardest to fix and very important. The IP rights, look, you can potentially go out and negotiate it if you didn't do it right and get the documentation signed. It's just, as I mentioned earlier, you're in a worse negotiating position. You don't have the leverage because if you didn't do it right, that person doesn't have an obligation to sign anything new. And so they're either going to ask for consideration or, you're going to be gambling on your friendship and their goodwill. Ignoring the governance and board structures, if you do that and you just operate as if you don't have a legal entity, then the government and the courts will not respect the legal entity. And so I mentioned, there's this passive, the shield for those passive stockholders. Well, you could destroy that if you're just running this company as if it's just you and Aunt Mildred gave you some money and you'll pay her back. And then last is just be thoughtful in how you deal with lawyers. And this one's always tough, right? Because I know clients don't want to call us because they don't want to pay for the fees, and I get that. And that's one of the reasons why, and I know I'm not alone in this. I say to my startup clients, call me anyway. I won't, if we just have a phone call and I can get you on the right page, I'm not going to bill you for that because I've saved us both time and pain in the future. And I would rather prevent you from making the mistake than get paid fixing the mistake. I feel much better in the long run if you're successful than if you keep breaking things and I get paid to fix them. That's a good business model until the thing falls apart entirely. I would rather have it be you are on a path to success and I am making sure that everybody can see that and it's obvious to outside investors.
Thank you, Sebastian. Adrian, do you think we should reserve time now for some questions on that topic, or should we wait till the end?
That's a great question. Actually, we do have two questions, so maybe we can get those answered and then move on to licensing. Does that work?
Yeah, while they're still fresh.
Okay, perfect. Kirsten, do you want to relay?
Yeah, so the first one is, what if you are a sole founder creating an AI native company that used Claude Code to create the prototype, and what are the IP questions there?
It's more you than me, Tali.
Yeah, so from an IP perspective, I would say anytime you're using any tool, whether that's software or libraries, any tool that's available either publicly for free, like an open source software that's available online, or whether you've paid for that tool, maybe with a subscription to some software or software as a service, you need to read your license agreement very, very carefully, because that is the contract between you and the provider of the technology or the provider of the underlying tool that will govern who owns what. So I don't know what the Claude terms of use are, but you need to read that very, very carefully to make sure that yes, indeed, you own the work product or the results or the output free and clear. I don't know if that's true, but it's really important. It's a very good question. You need to know the answer to that question. You need to be very solid on that answer, because a lot of people are going to ask you that question, including investors. And the last thing you want, even if you don't even need investors and you proceed with your company and you're doing great and you're leveraging some third-party tool or software or AI, the last thing you need is to launch your commercial product and then have Anthropic call you up and say, that belongs to me.
Regarding IP agreements, can these agreements specify IP related to the employment and let the employee keep IP they developed during employment that is not related? They have seen IP agreements that state that the employer owns any IP created during employment, and also does this also apply if you are a consultant and not an employee?
Right. Every consultant, right, as Sebastian said, every employee is automatically an employee, and the laws state that the work that you do as an employee are essentially automatically owned by your employer unless there's an agreement to the contrary. So an employee's inventions should be the employer's. But if the employee is bringing anything to the table before their employment and they want to make sure that the inventions and IP that they're bringing to the table stay with the employee, that's when you need to have a special employment agreement in place. And the same is true for consulting. So actually, the same and the opposite. So consultants who don't have a consulting agreement in place with you, they will by default, under most regimes, own the IP that they invent, which is why you always need them to sign an agreement saying that the company owns the IP that they invent. But in the same way that an employee can reserve something for themselves, so can a consultant. A consultant can reserve or keep to themselves any IP or inventions that they have in the past. And they can also very carefully word it to say that, oh, and by the way, I'm working for many companies. And so any inventions that I make or any IP that I generate not for you is also not yours. So yes, people can reserve rights to inventions that they don't want to be assigned or owned by the company. You just have to make sure that it's written very carefully that way. And there are going to be, so oftentimes in your company, you will have, or you will like to have, a scientific advisory board. And I think that's probably true for many of the folks in the audience. So this is not your board of directors. This is a board of scientific advisors. And usually those people work somewhere else. And very often, the place that they work might be a research institution or university. And even if not, those people are already beholden to their existing employers with respect to inventions and IP. And especially so if they're working for a university or academic institution. And so don't expect that your scientific advisors are going to be able to assign to your company their inventions. All they're going to be able to do is kind of advise you generally on the business, but you should know that you're not paying them for their IP. You're not paying them to contribute to the IP of the company, because their inventions and IP cannot be contributed to you unless their employer has kind of given them permission to do so, or unless they fall within certain narrow exceptions within the universities, in the case of a university employer, IP policy. So please be very careful when you're working with folks who are employed by a university, that you understand and that they understand all the rules of the road with respect to the obligations that they have to their employer. So all of these IP the IP documentation, setting aside the license, but including for your employees, consultants, and advisors, you have to be very, very careful with those. And I do encourage you to seek legal advice when putting them together.
Awesome,
So
thank you.
yeah, so it does segue to the license. So as I mentioned at the start of our meeting, very often it's the case that some set of patent rights or other IP, so patent rights, copyrights in the form of software, or trade secrets or know-how, or even data, sensitive data or clinical data, anything that's going to be kind of the foundation of the technology for your company, without which you couldn't operate, you're going to need to have access to that IP. So how do you get access to the intellectual property rights of another? Usually in the form of a license. So a license is just an authorization. It's just permission from the owner of the IP to allow you to practice that IP. And it's going to be a contract. I say usually written. It should always be written. In fact, if it's not written, it might be the case that it's not an enforceable contract. So a license is really, as I said, it's just permission from the owner of a patent right to allow you to practice that IP. And the permission means that that entity, that owner, won't come after you for infringing their IP because they've given you permission to practice that IP. And it's important to know that that's all it is. It's not a promise from the owner of the IP that the IP is good or useful or practical or it's going to be valuable. It's not a promise that the IP is going to lock up that technology from the rest of the world. It's just permission to practice rights that are held by another entity. So a lot of life science startups bring in their inventions from universities, and the universities who do this, the universities who have a practice of granting licenses to their IP to the outside world, often do so through a division often called the Technology Transfer Office, or some title similar to that. The role of the TTO is to manage the university's IP in the sense of making sure that they're aware of inventions that are coming out of the university, usually through inventor disclosure forms, and also monitoring that IP and deciding when to file patent protection on it and maybe when not to. And then the other thing that they do is they want to enable the commercialization of that IP. And many universities and research institutions have it as their mission to get their inventions and discoveries out of the university and into the hands of the public in favor of the public good. So enabling commercialization is maybe one aspect of it, but really it's to enable the IP to get out there and to turn it into products and services that can be of value to our world. And the TTOs usually follow standard policies and templates. And especially universities that have a robust TTO, that they're doing a lot of licensing, they're going to have a very structured way of doing things. They're going to have experts within their offices who understand and know IP law and contract law, and are very sophisticated and can negotiate these deals at any level, whether it's a very small brand new invention that just is subject to maybe a provisional, or whether it's very advanced technologies, even technology maybe that the university has put into the clinic. The TTO specialists are able to negotiate all flavors of those agreements. And the TTO is probably going to be your kind of entry point into the discussions in terms of a license to university IP. You may be introduced to the TTO by somebody who works at the university, maybe the inventor of the invention, or maybe you reach out to the TTO directly yourself because you saw on the university's website that there's a patent or an invention that you're interested in licensing. So you're going to make an introduction to the TTO one way or the other. And I encourage you from the very beginning to establish a professional and respectful relationship with your TTO officer, and make sure that you're very clear and transparent in terms of who you are and what you do and what your plans are, because this is going to be your relationship partner through the entire experience, not just of negotiating this foundational and pivotal license agreement for your company, but you'll also be likely interacting with this person or their office over time throughout the course of the relationship. And I'll mention additional current and future critical stakeholders. So Stakeholders in what this license agreement looks like are going to be obviously you, but also the inventor of the technology, the person at the university whose name is on the patent. So that person is going to be interested in to see how this agreement works and interested to see how their invention is developed and exploited. But I mentioned future, so you heard in Sebastian's portion a lot of discussion of investors. So just as with all of your corporate formation documents, all of your IP agreements, this in-license is going to be scrutinized not only by your investors to make sure that you've done it right and that it's a sufficient foundation to operate and grow your company, but it will also be scrutinized by potential future business partners. And if for some of you, if the vision for your company is to bring in foundational IP, grow it, develop it, advance it to a certain point based on how much money you have and how much money you've budgeted for, and then perhaps partner it off to a larger company to take further or to commercialize or to advance in the clinic, and that might be a pharma company, that company's also going to scrutinize this agreement. And unlike an investor who's going to look at it and say, oh, this was a good or bad contract, or this is going to be good or bad for the business, a future partner like pharma is going to look at this contract and say, can I live with it? So it's not just that you're negotiating this agreement for you and your company today, you're also negotiating it with an eye to how is a pharma company going to feel about stepping into my shoes in this relationship in the way that I've negotiated this contract. And most university tech transfer offices understand that. So when you say to them, I understand that your standard template is requiring the definition reads this way, but I'm planning to partner this technology to pharma in 10 years, and I know they're not going to like that definition. Can you please work with me to adjust it to make it more partner friendly or more partner favorable down the road? And very often it's the case that the TTO will understand that sensitivity, that future stakeholder, and make an allocation for that. So we don't have a ton of time left, but I just want to talk through what to kind of expect in a typical license agreement. So you're going to have identified the patent right or the IP, the software, the data, whatever it is that you're taking a license to. And within that world, you will have access to a certain field of use in which you can exploit it. And that field of use will track what your company is doing and what you anticipate your company doing in the future. So if there's an invention that has very broad application, let's say it's a patent that could be used in humans, in animals, in environmental science, in space, the university might view that as very different fields of use through which they can exploit their inventions in very different ways. And so they might say to you, well, I see that you're in veterinary care, and so I'm only going to give you a license to use these patents in veterinary care, reserving the right to use those patents in all of these other fields of use. And the way that you need to ensure that you're getting the right field of use for your business is to show the university that you have an actual plan in that application, in that field. And if they trust and have reassurance that that is truly the direction that your company is going to take, then you're going to be much more likely to be successful in securing the field of use that you want and not something that's too narrow. Another aspect of a license will be the scope. You may have heard there are exclusive licenses, there are non-exclusive licenses. An exclusive license means you exclusively have rights to that IP and nobody else has rights to that IP within the field of use. And not even the university, although the university will reserve the right to practice IP for their own internal research and academic purposes. And if the invention was funded by the US government also reserves rights, but setting that aside, you are going to be the only commercial player in your field of use. But if it's a non-exclusive license, it means the university is giving you rights to practice that IP, but they can give that same right to anybody else. And another way of scoping a license is territorial. So they might say, well, we see that you're in the US, but we think there's a real need for this IP in Europe or in other territories or countries. And so we're only going to give you the license in the US. Whereas, of course, your vision is to go worldwide. So you're going to ask for worldwide rights, and that's just part of the negotiation. And then the economics. So I do have slides on economics, and I don't know that we'll be able to go through all of them, but I do want to alert you that most likely you will have to pay an upfront fee to the university, some amount. It can be nominal, like maybe $1,000. It can be huge, like $1 million, just depending on the nature of the IP and how mature it is. And many universities will also ask for equity in the startup. So you just heard from Sebastian how that works, but you should be prepared to give the university some equity in your company. I don't really want to get into like what's market or what I usually see. I just don't think we have time for that now, but do be prepared for that. And many academic institutions also ask that their equity not be diluted for some initial period of time. And that's not true for all universities, but you should be prepared that that might be part of your negotiation. And I want to emphasize that all of this is negotiable. Universities are rarely going to just say only it's our way or the highway. And so another reason why you should be working with a licensing professional who can give you advice on ways to negotiate these numbers. The university might ask for milestone payments. So as you achieve certain milestones in the advancement of the invention, they might ask for payments along the way. They might ask you to pay them annual fees to hold on to that license. And actually I don't have this on the slide, but they will also expect that you are going to reimburse them for the patent expenses that they've incurred in bringing that in filing for the patent. And they're also going to expect that you're going to pay for those patent fees going forward. So that's a huge issue that you need to be aware of, and you need to get your hands around what are the patent expenses in the past that I'm going to be responsible for, and what is my sense of the patent expenses going forward, and can I pay for those? And another important element of a license agreement is going to be diligence. So the university is going to expect that you are going to be diligent in advancing this IP and advancing the inventions, and you're going to actually put it to work, and you're not going to put it on the shelf, and they're going to want to see real plans for how you're being diligent in advancing the IP. And then we can't leave without talking about royalties, even if it's just one slide, to say that the universities, almost without exception, although there are exceptions, will expect to see a royalty, which is essentially a revenue share. It's basically the university saying, once you finally commercialize this invention, and I hope that it's sooner, but it's probably later, especially in the world of life science. But when you finally bring that drug to market and you actually see revenue from it, you're going to give me a revenue share. You're going to give me a piece of all of the revenue that you collect from selling that product. I'm going to receive an ongoing steady stream of royalties every quarter and every year for as long as our agreement is in place, or thereabouts, for as long as the patents are alive. There are ways to have your royalties be reduced over time, and they can be kind of complicated. And also your royalty rates and your royalty reduction provisions are negotiated. So I think that in the interest of time, I should probably wrap it up here in case there are questions, and I can maybe get to specific topics that are of interest to the audience instead of covering things that might not be relevant at this point.
I think that's been fantastic, and we will be sending out your slide deck with our follow-up email. So if they want to continue the conversation and they have more questions, they can reach out to you, because we'll also give your contact information in that email as well. But we have two questions, if you're willing to take the time to answer those. Anyone that has a hard stop, feel free to log off. Like I said, you'll be getting the recording, so you can follow up with that information when you receive that. So Kirsten, I'll let you ask the questions.
Yeah, so regarding IP and royalties, what about an expert opinion, and what is the impact if it is used in an AI model?
I don't understand the question.
Um,
An expert opinion.
Stephanie, if you want to take yourself off mute and maybe provide a little bit more context, that'd be amazing.
Sure, Adrian. So if you have a clinician, for example, who's providing some sort of novel insight, right? Like there's clinicians that do research or have unique protocols or have a unique view of a certain specialty, right? And they might be contributing that
Hmm.
but in digital fashion, right? So it's no longer just a one-on-one conversation. It could be something that's multiplied, or it could be used to train a model. What happens there?
So I think what you're asking is, how do I, it sounds like that person would like to have a revenue share in the revenue of the business. And how do I do a revenue share with somebody who's contributing data or knowledge or expertise? That's very, very hard because the key to royalties is making a very clear line between the invention or the IP and the data and the final commercial product. It needs to be very clear that those are tied so that you can show definitively that, yes, my commercial product was a direct result of the intellectual property or the data that you contributed. And I need to be able to, that should be very an objective, verifiable determination. So general expertise and advice and thoughts, I would say that that is that's dangerous ground because you could be opening yourself up to essentially a revenue share for somebody who contributed to the business, but not necessarily in a way that was a very clear line between their contribution and the final commercial product. So I would think that somebody contributing in that method, in that manner, would be better compensated in the form of equity, where they can kind of share, in the general proceeds of the business, as opposed to being entitled forever to royalties based on actual sales.
Okay, thank you.
When you first asked that question, I wondered whether you were asking me about expert advice on economics. So I will say that I cannot give, and most lawyers cannot give you advice on what is IP worth. How much is my IP worth? How much is this patent worth? What should I pay for it? What's market? That's like saying, I have a condo on the beach in Del Mar and I'm now buying a farm in Montana. What's the comps? It's so different. Every technology is so different. Every market, every field, how advanced is the IP? Are you have issued patents? Do you have provisionals? Is the market brand new? So there are consultants and consulting firms and experts whose job it is to value IP and can kind of give you that kind of guidance. But if you're asking your lawyers for that answer and they're giving you an answer, just know that it's most likely kind of anecdotal and you should probably be seeking independent business judgment for that.
Okay, that's good guidance. Thank you. Yeah, I know I've been involved with deals where a clinician was compensated by, you know, in relation to a specific product, but it's a little more messy now with LLMs. So it sounds
Yeah.
like the precedent still stands and you still want to make it as clear cut as possible.
Yeah, and an investor's going to look at that too and say, "Oh, wait, how do you know if the contribution that this person made this year is directly tied to a product that you're commercializing in 10 years? Won't it have evolved away from their contribution at some point where it doesn't make sense for you to continue to be sharing in the revenue with them?" So you have to be really careful with that.
Thank you.
Last question. What if the technology is a software developed in a university, but with no patent, copyright, or trademark protection?
So software is a work of authorship in the same way that a song or a play or a poem is. It's something that somebody wrote down with their typed up or wrote down. And because it's a work of authorship, it's automatically protected by the copyright laws. So software is already copyrighted and copyrightable. It may or may not be protectable by patent. So if a university has written software, developed software, that is already IP and you need rights to it. And if you want the ability to copy that software, to install it even on your machine, or to modify it if you have access to the source code, you need permission. And the permission is the form of a license. So it's not a patent license, it's a copyright license. And it kind of goes back to the Claude question, which is make sure you know what that thing says.
Amazing. That took us a little bit over time, but not too much. I want to say thank you. That was a fantastic presentation. I thought I learned a lot from it. Again, I want to just let everyone know that we will be sending out an email with the slide deck, also contact information, so you guys can continue the conversation with Polly or with Sebastian if you would like to. Just a reminder that a survey is going to pop up at the end. I would love if you could take a moment to fill that out. Huge thank you for such a thoughtful and an engaging discussion, and a special thank you to Tali and to Sebastian for sharing their insights and their experience. We are hoping to see you at some future events, so please check out our events page on our website. Otherwise, we will see you guys at the next one. Thank you so much.